Let me ask you a question. Have you ever wondered if your fundamental rights are, truly absolute? Like, can we actually just say or do whatever we want? Well, it turns out the answer is this fascinating balancing act between some profoundly deep liberties and, well, necessary limits. Welcome to this explainer. Today we're going to be decoding a really crucial part of the Constitution, Articles 15 through 19. We'll be uncovering that dynamic tension between the incredibly broad freedoms we get to enjoy as citizens and the restrictions the state can legally slap on to maintain order and equality. All right, so here is our roadmap for today. We're going to start with the promise of equality, then move into opportunity in public service. After that, erasing historical injustices. Then we'll hit the 6 democratic freedoms, and finally wrap up with the limits of freedom. Let's dive in. First up, Section 1, the promise of equality, focusing on Article 15. So what's really fascinating here is the absolute prohibition this sets up. Article 15 explicitly prevents the state from discriminating against any citizen based only on religion, race, caste, sex, or place of birth. And it gets super specific in practice, too. It guarantees equal access to shops, public restaurants, hotels, and even things like using wells, tanks, bathing ghats, and roads that are maintained, wholly or partly by state funds. It's deliberately designed to make sure public spaces are, actually public for everyone.
But here's a pretty brilliant constitutional twist. Sometimes achieving true equality actually requires unequal treatment. I know it sounds counterintuitive, but while the general rule is no discrimination, there are some incredibly vital exceptions. The law allows the state to make special provisions for women and children, and crucially, thanks to various amendments over the years, it explicitly allows for reservations in educational institutions, and yep, that includes private ones, for socially and educationally backward classes, scheduled castes, scheduled tribes, and economically weaker sections, or EWS. It's just a fantastic illustration of how the law actively tries to level the playing field rather than just ignoring the disadvantages that are already out there. Moving right along to Section 2, Opportunity in Public Service, which is covered under Article 16.
So, Article 16 guarantees equality of opportunity for all citizens when it comes to employment under the state. But just like we saw with Article 15, it's immediately balanced out by exceptions. It turns out the state has the explicit power to reserve posts in favor of any backward class of citizens that, in the state's opinion, just isn't adequately represented in state services. It also allows for reservations in promotions and even up to a 10% reservation for economically weaker sections. So the main takeaway here is that equal opportunity in public service actively accommodates proactive measures to make sure we have diverse representation. Which brings us to a massively important number in Indian constitutional law, 50%. Because you might be wondering, how far can these public service reservations actually go? Well, in the landmark 1992 Indra Savni case, the Supreme Court established a really vital ceiling. They ruled that total reservations should generally not exceed 50% of the available posts. And if we actually look at how this has evolved over the decades, we see this constant, continuous refinement. It goes from that 1992 cap right up to the 2019 validation of the 10% EWS quota, all the way to a 2024 ruling on subclassifications within SC and ST categories to ensure equal distribution of benefits. And hey, it's still a highly active landscape today. We're expecting major rulings by March 2026 on whether converting outside certain religions revokes scheduled caste status, plus states implementing a 25% right to education quota in private schools by May 2026. So, lots of movement here. All right, let's get into Section 3, Erasing Historical Injustices, covering Articles 17 and 18. Okay, so Article 17 boldly abolishes untouchability and makes its practice a punishable offense under the law. But here's a detail I found just absolutely fascinating. The term untouchability itself, it's actually never literally defined in the Constitution, or any act for that matter. Instead, the law relies entirely on historical context. It's not meant to be read in a strict grammatical sense, but rather understood as the specific practice that developed historically in India out of the Hindu caste system, where certain sections of society were severely looked down upon. Similarly, Article 18 attacks social hierarchy by abolishing titles. The state is flat out prohibited from conferring titles on individuals, with the exception of academic and military distinctions. Now, you might be thinking right now, wait, what about major national awards like the Bharat Ratna or Padma Vibhushan? Well, the 1992 Balaji Raghavan case cleared this up perfectly. The Supreme Court held that these national awards are actually not titles, they're awards given for rendering service to society or the state. But there is a catch. These awards cannot be used as prefixes or suffixes to your name.
Okay, Section 4, the 6 democratic freedoms, which brings us to Article 19.
Under Article 19.1, citizens are guaranteed 6 core fundamental democratic freedoms. We've got freedom of speech and expression, the right to peaceful assembly without arms, the right to form associations or unions, the right to free movement throughout the territory, the right to residence and settlement anywhere in the country, and finally, the right to practice any profession, occupation, trade, or business. This is basically the core playbook of your liberties. And when you really map out the expansive scope of these rights, you start to see just how incredibly broad they are. Freedom of speech means you can express your views freely and openly, without fear, using whatever means you want, writing, speeches, banners, symbols, you name it. The right to form associations is also huge. It even covers forming cooperative societies, which was a provision added by the 97th Amendment back in 2011. Oh, and here's a great little nuance. The Supreme Court has held that your right to form an association inherently includes the right not to join one. Pretty cool, right? This really goes to show just how wide that freedom of speech umbrella is. I mean, the courts have ruled it includes freedom of the press, the right to internet access, and even the right to silence. Actually, in a 2004 case, hoisting the national flag on private buildings year-round was also declared a protected right under this. But, and this is a crucial but, hate speech is explicitly not protected. You have a profound right to express your views for sure, but you absolutely do not have the right to incite harm.
Which perfectly transitions us into Section 5, the limits of freedom or reasonable restrictions.
Because, let's be real, for every single freedom granted in Article 19, the Constitution provides grounds for reasonable restrictions. Freedom isn't a blank check. The state can legally pass laws limiting your speech or your assembly to protect the sovereignty and integrity of India, the security of the state, or even just to maintain friendly relations with foreign states. They can also place restrictions to maintain public order, decency, morality, or to prevent the incitement to an offense. So the absolute key takeaway here is that your individual liberties always have to be balanced against the safety and stability of the nation as a whole. And this reality check extends right into your physical movements and choices as well. The rights to move freely throughout India, to reside anywhere you want, or to practice your chosen profession, all of those can face reasonable restrictions in the broader interest of the general public. Furthermore, the state can actually restrict movement and settlement specifically for the protection of the interests of any scheduled tribe. This is to make sure that the expansion of one citizen's freedom doesn't just trample all over the cultural and physical borders of vulnerable indigenous communities. Now, here's a really surprising piece of history. This list of freedoms, it isn't actually carved in stone. The original Article 19 actually had 7 democratic freedoms. Yeah, Article 19(1)(f) used to guarantee the right to property, but it was completely repealed by the 44th Amendment Act in 1978. They literally demoted the right to property from a fundamental right down to a mere legal right under Article 300A, which now basically just says no person shall be deprived of his property except by authority of law. So, I want to leave you with this thought to ponder as we wrap up today. If a fundamental freedom, something as massively significant as the right to property, can just be entirely repealed and reclassified by the stroke of an amendment, how might our remaining fundamental rights evolve, expand, or even shrink in the future? The Constitution, as you can see, is not just some dusty historical document. It's a living, breathing framework that responds to its time. Thank you so much for joining me for this explainer on Articles 15 through 19, and remember to keep questioning how these profound rights shape the world around us.